please, you can't do this. Crying, everything.
And welcome back to the Law News Network. I'm your host, Amy Dash, and I'm here with Michel Bryant, who is a local attorney. Thank you so much for being with me.
Pleasure, Amy. Good to see you.
You're a veteran legal expert.
One or two cases here and there, yeah.
I can't believe this call that we just heard
What?
from Louis Toledo to his dead wife's best friend, basically talking about how he used to take the kids to soccer practice.
Model father.
He paid off her debts.
Yes.
She had about $5,000 in credit card debt. He paid it off. This is mind-boggling. So is he a hero now because he did all of this, but then he admits that he killed her? So what is he doing? Is he trying to justify why he killed her? Like, look, I'm this great guy. I just happened to murder her.
That's right. Come on, it's one strike.
And the kids potentially.
You know,
but listen, I paid off a couple of $1,000s in credit card debt.
I get credit for that, right?
Yeah.
This is what happens when somebody is in jail for a period of time, and all they have time to do is think. How do I create a narrative here that makes sense, that helps me somehow? And so that's what we're hearing. We're hearing this conversation with the victim's girlfriend, where she's doing not a whole lot, but
Which is what you should do if you ever get a jailhouse 911 call.
And who
Just
doesn't?
let the person talk. Don't open your mouth. It will all be used as evidence against them.
So he's laying this foundation that he is a great guy, that he's always been there, that she's the bad guy in this scenario. This is how I got screwed, and this is not my fault what happened. I'm always amazed in these jailhouse calls how the person making the call from jail doesn't think it through. Like, this is being recorded. You realize that?
Yeah, that amazes
On the
me
other
too.
hand, maybe they're so clever that they know it's being recorded, and therefore they're using it as an opportunity to kind of lay some groundwork for their future defense.
I think it's safe to say that was not the case here, considering
Come
that he
on.
also confessed to police after they read him the Miranda rights multiple times and did not ask for a lawyer at any point throughout multiple interrogations.
Okay, yes, there's that. Yes, there's that. So he's just doing his best to just dance around the facts that are so overwhelmingly against him.
Yeah, and so the fact that he's talking in this recording about, well, if she had just been honest with me, do you think he's insinuating that maybe she'd still be alive if she just admitted to the affair? Because he seems to be harping over and over and over again about how he caught her, about how her plan was to just get away with this and continue on with her life. And really, it seems like the deception is what ate away at him. And he kept asking her, even when he confronted her at the job, tell me the truth, tell me the truth. Yet he caught her with all these text messages, talking about being with this guy. And meanwhile, she's swearing on her kids' lives that she's not with anybody else.
Yeah, I mean, this is obviously very common. I mean, you have an obsessive spouse and a very deceitful other spouse, and it's going to lead to this kind of conflict. Obviously, it doesn't always escalate to the level this has, but it's very typical. Obsessive, possessive. He probably doesn't really believe her from the start, but until he's faced with the text messages and her ultimate confession, does he really let it get a hold of him? And then it does. I mean, this is crazy, out of control behavior.
Yeah, it's fascinating that you say that, because it is at the point where she does finally confess that things go terribly wrong, and he, as his friend testifies, he said that he snapped. So something in that fact pattern tells me that even if she had been upfront with him from the beginning, she might still be dead. I mean, it's not necessarily that she was hiding things, as he claims, but the fact that the affair in and of itself was going on seems to really get to him.
The point at which it was confirmed is when he went off the rails.
But he had the confirmation before that. It's when she confirms it.
That's what I'm talking about.
Yeah.
Because, until you're sitting there with the person, that you trust and believe in, and they basically shoot you down, you're in denial. You're in denial.
Yeah, exactly. And so what do you think about this, how he really takes the best friend through everything that happened? How will this tape that we just heard weigh upon the jury's determination, do you think?
It doesn't hurt him, at least. I mean, because there really are times when he sounds like a decent guy. Even when she first suggests that we need to break up. He's like, okay, fine. I know you'll find the grass is not greener elsewhere. I know you're going to come back to me, the good, solid citizen. That is not unreasonable. To at least give somebody the freedom to do that. It may be a little bit diluted, but it's not an unreasonable belief that, okay, do what you have to do. I'm still here waiting for you. That's not a bad thing to put in front of the jury. What I think the problem here is that it just seems so manufactured. The timing is such, the method by which he's delivering the message, it just doesn't smell right,
Do you find it amazing, because I do, that he can be so coherent, logical, tell, like you said, a chronological story pattern here. Meanwhile, he could also be this psychopathic killer who snaps and murders 2 innocent children and his wife, and then just be able to bounce back into this alter ego character that we hear on the 911 tape.
I mean, we see this a lot with these kinds of cases, and I'm no shrink. I don't have the credentials for that, but it's not unusual to see that sort of, certainly not a split personality, but it's kind of a bipolar kind of approach to things where you can compartmentalize. The evil person that did these things is not me. I'm over here in this more normal room, and I'm a perfectly regular, reasonable person. So it's not unusual.
Yeah, and I was talking about this before with the producer. His story that he tells police is that she attacked him and he karate chopped her in the throat, and that's when she died. And I guess the prosecutor's story is that the children, or one of them, may have witnessed it, and that's why they had to die. Do you think that based on him telling that story to police, the defense should really bolster that argument that this was self-defense and not, in fact, second or first degree murder?
It's funny that the self-defense argument hasn't really been touched on that strongly. It's more accidental. One thing led to another, was accidental. I think the self-defense argument's a better argument. I don't believe it either, but I think it's a better argument. And then when you factor in his own statement to the cops that the kids came in and said, what happened to mommy? What did you do? I mean, it ties him so closely with their discovery of what was done.
Yeah.
How does the jury disconnect those events?
Yeah.
They have to find for first-degree murder that he, at that point, shifted from some sort of heat of passion murder of their mom to a calculated, I got to get rid of the witnesses kind of mindset. That's what leaps from second degree to first degree. I think the prosecutors laid that, and I think he can use, if nothing else, the defendant's statements to the cops in that interview.
Yeah, and you said that you felt that the prosecution articulated that well in its closing argument by the fact that they took little colorful details from the case and illustrated to the jurors basically how they apply to the elements of the crime. Because when the jurors go back there to deliberate, they are looking at the jury instructions. They are looking at the elements of the crime, and they have to, like puzzle pieces, take the different facts of the case and see if they fit within those elements in order to get a conviction on the charge. This is not, sometimes it can be emotion-based, but typically my experience has been that the jurors like to make sure that they are following the law, no matter how they might feel on the emotional side.
Sure, they do their best, but let's face it, it's complicated, tricky stuff.
And with children, it's always,
it's
to give
very
that caveat,
hard
it's
to
always
ignore
emotional.
that emotion.
Right.
I've covered cases. Luckily, I haven't tried any involving children as victims, but I've covered many, and it's
you can see those faces right there.
Oh, it is.
It's difficult
how do
to
you
even look at
just
them
say we
because
can't?
they're so beautiful.
Yeah. How do you just ignore any sort of justice for those kids? It's a very tough thing for the jury to do. But on a more nuts and bolts level, they have to look at these instructions. And those who were watching yesterday got to see a jury instruction conference, which I'm telling you, sometimes it's done in chambers, and you really don't see it exposed like it was yesterday.
Right.
It's fascinating because this can change a case. These jury instructions are probably the number 2 reason for appeal. Giving the wrong instruction, or improperly giving it, or an apostrophe's in the wrong place, which leads the jury to think that you have to have the 3 elements rather than an either-or scenario. So to see that all unfold is fascinating, and now the jury has to wrestle with that. So what the prosecutor did, I think, effectively in closing, was he took each instruction, especially those dealing with the difference between first and second degree murder, and he said, here are the facts that elevate from first to second degree, and I just mentioned those, where the defendant had some point in time in which to consciously decide, I'm killing these kids. Very different than a heat of passion murder.
Right, but I had asked you during the break, couldn't it also be argued that all of this may have been going on within a very short time frame? And so after he kills the wife in a rage, if that's what in fact happened, and he sees that one of the kids witnesses it, isn't it also reasonable to make that leap that he was still within that period?
And Amy, then I told you you're crazy.
Right.
No, because you remember that to create that malice aforethought, that piece of mental imagery that takes it from second to first degree, can happen like that.
Right.
You don't have to have a day to think it over. You don't have to have a minute to think it over. It just has to be a line that the jury believes was crossed that changes his mindset from heat of passion, defensive, accidental death to I'm killing these kids, and it's a scary moment.
And to me, it just makes more sense that this is their stepfather. He's obviously spent a lot of time with them. He plays video games with them. He takes them to soccer practice. They call him dad. When he is interrogated by the police officers and he's shown their pictures, it's not long before he goes into a bathroom, breaks a mirror, and tries to kill himself with the shards of glass. So obviously, he is affected by these children in some way or another. So it would seem to make more sense to me that maybe he was still in the heat of the moment when he killed the kids, because how could he kill them otherwise? How could somebody consciously decide with premeditation to kill two beautiful children like that? But listen, I'm not
nice
a psychopathic killer. So I can't put myself in those shoes. So do you think that that's something that the defense should really take a crack at as well, to try to say, but then again, that would be an admission. So there's the problem with that. But his life is on the line.
Yeah,
maybe they should have gone that route.
Theories. They're going to have alternative theories. And I think in this particular case, a win is keeping this guy alive. I've already kind of moved past the liability phase, the guilt phase. I'm thinking, are they going to be able to keep him alive in the death penalty phase? So while I think
it seems they're not there. They're still fighting the first-degree murder charges.
Oh yes, and they're certainly not
with
giving that up.
With flat-out denials, right?
They're not giving it up. No, don't mistake what I'm thinking there. They're going to make those arguments. No body. No, I mean they're going to make all of those arguments.
But do you think they should have gone that route instead of maybe just trying to get that to a lesser charge of second-degree murder? It
wouldn't hurt. I mean, what do you got to lose, really? I think it's a reasonable argument. I don't know that it's believable by everybody on a jury, but it certainly gives them something to think about. And as you know, doing defense work sometimes, it's really just to give them alternative theories to latch onto, and if nothing else, maybe it hangs them up and yet a mistrial.
Because of course you don't want to admit to 2 additional murders, but listen, if he's already admitting to killing the wife and then saying the friend murdered the kids with an axe, you've got a lot of evidence there against this guy that could sway the jury. So why not then try to say, listen, he killed the kids, but it was done in the heat of the moment as well.
Yeah.
Then you're at least saving his life because the death penalty is only on the table with regard to the kids.
Yeah, no, I think it's so risky because if you're the defense, do you give up that kind of position? I mean, that's a lot of giving up, and obviously you're going to have a conversation with your client, and if the defendant is steadfastly denying that he did those things, he's not going to really like that defense move, What do you make of the defense's choice to not put him on the stand? We've heard so much from him to begin with this call from the prison cell to the victim's best friend, with the police interrogations. Would it have benefited him, because it's a death penalty case, to at least get him up there so that people could hear and see his emotions in person? Would that, in effect, maybe humanize him and lessen his chances of being put to death? I would say no in this case. I think they get their best, vision of him through that phone call that we just heard to the girlfriend. He's a little more rational, reasonable. You put this guy on the stand, I don't care if he's wearing glasses or not, it just seems to make him look a little more nerdy. You're going to open him up to some subjects that he's not going to want to talk about, that will be fair game. And it'll go far beyond what has been somewhat controlled, because the prosecution can only put on so much. I think you're always weighing that question: should the defendant be put on? Should we do that? In most cases, the answer is no, for this exact reason. You're opening up so many problems, and in this case, I think the benefit, if any, is far outweighed by the potential to sink this guy even further into the facts.
Yeah, and so what do you think that the defense needs to do now, in light of what we heard from the prosecution, to try to counteract some of that powerful closing arguments that they delivered to the jury?
They've got a job ahead of them, and we know they're going to pound away on the fact that there were no bodies, but to me, once you have the defendant saying, "I'll never tell you where the bodies are," that issue probably out the door. So it's not going to be very. That's why they brought it up, to bring a directed verdict or a motion for dismissal after the end of the prosecution's case. It was dead in the water. We knew that, but it'll come up. I'm sure they'll mention it. So they've got that going. They're going to go with the accidental death issue, and then they're going to try to create the reasonable doubt as to how the kids were killed. Because we really don't know specifically. We know what his version, we know what the defendant's version is, which is a horrible vision for these jurors to have to wrestle with, but we really don't know. And he's got to drive a truck through that hole in the prosecution's case to create reasonable doubt.
Yeah. And so if he is convicted on all three charges, the first-degree murder with regard to the children and the second-degree murder, just explain, where do we go from here? Is he guaranteed the death penalty, or there will be a hearing, and how will that factor into the final determination?
You know, Florida, unfortunately, very commonly has these kinds of cases. So they have the death penalty qualified jurors. That's what these folks are. And they've just recently changed the law in Florida. They used to have the opportunity where a judge could actually impose the death sentence without the jury's input. And then for a while it was 10 jurors had to say death. Now it's unanimous.
Well, isn't that because the Supreme Court ruled that it's unconstitutional to have one judge make this type of determination?
Sure.
And can you go into why that is?
Well,
it's the cruel and the prohibition on cruel and unusual punishment.
There's obviously an Eighth Amendment issue overriding, but I think it's more social and political than that, to be honest with you. I mean, that's a horrible position to put a judge in. You know,
interesting.
To have that kind of power. I think it's back in the good old days when you had executions. Like
I was just thinking that one executioner versus an entire village.
Exactly. So
calling for his head.
Exactly. So I think there's a little of that going on here, and I think it sounds more fundamentally fair to have the jury decide it unanimously. Okay, and if we can't decide it, then it defaults to the lesser penalty.
And it makes it comparable to other elements of our justice system where you need the jurors to find unanimously beyond a reasonable doubt that somebody's done something in order to get a conviction. So you should probably have the same standard the Supreme Court is saying when you're deciding whether to kill a person or not as deciding their guilt.
Exactly. And so the jury has a lot of work yet to do. I mean, unless they are hung or they find him not guilty, they've got the bigger job yet to come.
Yeah. And so this is the last question, and then we'll toss to a clip. But with regard to the children, you did have a investigator take the stand, and he was asked point blank, do you have any evidence that he killed these kids? And he said no. There were some blood stains that matched the DNA of the little girl, just a couple of them. Is that really enough to directly connect him to the murders of the children? I also was tapping into the fact that during his confession to the police, he said that the children were killed with axes by the friend, so obviously implying that he witnessed that or had knowledge of that. Is that enough? I mean, how do we overcome this testimony from the investigator who's basically saying, no, we don't have anything to prove that he actually did it?
Yeah, and we know there's no direct evidence of that, and it's all circumstantial, so you add these little bits and pieces together to get the jury where you want them to go. Yeah, we found her blood in a number of places, as I recall, which is consistent with a gruesome axe-type murder and moving the bodies somewhere.
Yeah.
So I think critical here is the defense belief or story that the friend was somehow involved in doing this, because I know he was afraid he might go back to jail. He had a history. He was on probation, I think. I just don't know that is a believable motivation for somebody who's virtually a stranger to kill these kids. I don't get that. I don't think that's believable. It's more believable, as the prosecution suggests, that this guy saw what the kids saw and he's got to get rid of them. It's a horrible mindset. It's hard to believe a father or stepfather would do that. But to me, it's more believable than the neighbor just decided to do it.
Right, but by the same token, the lack of a plausible alternative doesn't implicate somebody else just because you can't think of someone else who did it more likely than him.
Of course. So I think, to answer your question, I think there are enough pieces that brought together circumstantially, as in most cases we find, it's all circumstantial.
Yeah.
There's enough for the jury to make that connection.
So because it's a death penalty case, does the fact that it's so largely circumstantial make it vulnerable to an appeal? And can we expect that even if he does get the death penalty and is convicted on the first-degree murder charges, that we're in it for the long haul, that this guy's probably going to appeal his death penalty sentence for decades, potentially?
No doubt, yeah, and in fact, it's generally mandatory. So, yeah, that's going to happen. What the court
does he have a great shot, though? Because there is no direct evidence, can he go back to the appellate court and say, look, the investigator said that there is no evidence connecting me to the murder of the children?
I don't think that in and of itself is going to be enough. It's not going to carry the day. It's a factor, but I think, as usual, the appellate court defers to the trial court, and they're looking for errors that are reversible. They're looking for something that is beyond the jury's province. They don't want to invade the jury's business.
Right.
So if they believe that what was presented to the jury could get a reasonable person the conviction, they're not going to reverse it.
Yep, yep. Well, thank you so much. I appreciate it. I just want to toss really quickly to a clip, and then we are expecting to go back and hear the defense's closing arguments in the trial of Luis Toledo, and this is out of Florida. But let's listen now to his speaking with investigators, saying point blank, they will never find the bodies.
Good afternoon.
You remember me?
I did.
Okay. So, just want to go over a couple things with you. Shouldn't take too long. The jury's seen a number of statements Mr. Toledo made.